Business Unity South Africa is taking its issues with the employment equity sector targets to court. Busa says this does not mean that it is against the Employment Equity Amendment Act or the sectoral numerical targets set out in Section 15 of the Act. Let's now get into more detail. Khulekani, Mathe, CEO of Business Unity South Africa, joins us live now. A very good evening to you and thank you so much for your time. So you say that in your statement you're not fighting against transformation, but it must be implemented correctly. How so?
Good evening, and thank you for the opportunity. So, firstly, the process that is set out in the Act, the Amendment Act, Section 15A, outlines the process that must be followed in determining sectoral targets, starting with the identification of sectors all the way to the determination of targets and the consultation that must happen. Our contention is that that process was not followed properly, which has resulted in sector targets that are in some instances unachievable and in many instances quite irrational and flawed. Yeah. What do we mean by that? These sector targets are a product of a process that was not sufficiently consultative, which means that the views of affected parties were not taken into account. A specific and concrete example is that because the identification of sectors was left at a very high aggregate level, we asked the minister to determine subsectors so that you do not lump together sectors whose skills requirements are vastly different. Yeah. That was not done, and we have now targets that are, in our view, quite difficult to achieve.
So, when one reads the Act, right, Section 15A is very clear. In part, it speaks about the fact that while the minister is expected to identify the national economic sectors and after a process of consultation, then set the numerical employment equity targets. But I wonder then, have you been talking? And if you're talking, why were you given the 30 days that one sees in that particular law?
We have been talking with the department for as long as 2018, because at the same time as the draft amendment bill was in Parliament, the department also published draft administrative regulations which would effectively implement this. Now, we've been talking, but we've made it clear during that process that because the enabling legislation was not yet in place or was not effective, those negotiations or engagements were really informal. What counts is what the minister has done since the 1st of January when that legislation became effective. Now, what has happened is that the process that is set out in 15A was simply not followed. Employers were not given sufficient time. In some instances, they got for the first time the presentation the night before, the day before the actual meeting, which was supposedly a consultative meeting. Some of those meetings had 800 to 1,000 people in them virtually, and only for an hour, no time for proper engagement with the presentation and the presenter. So it was very clear that this was not consultation. It was merely a tick box exercise. And this is why we're raising our concerns, because none of the things we put before the minister were taken into account in the process.
Sure. And when you speak about so many participants in one meeting and also not some of these concerns being addressed, one then wonders if you get a sense that there is a true understanding of the impact that this could have on some of the companies who cannot be able to meet some of these targets.
Well, we really would have preferred to engage with the department, and we offered to work with them to really try and address these issues sectorally and make sure that these problems don't arise. But we were left with no choice, which leaves us to really wonder whether there is a real commitment to make sure that proper transformation happens. Because when you do something and you do not do it properly, you open yourself up to those who are opposed to transformation. We are not opposed to transformation. All we think is do it well so that we can get on with the job. But if you do a shoddy job, you will be attacked by those who are opposed to transformation and stall the most important goal of transformation in our country.
I have to ask this because you and I have had a conversation around this before, and of course there is that other challenge by the Democratic Alliance around some of the issues that they have with this particular piece of legislation. And then now comes this challenge. Someone who's watching us tonight is asking, are these two separate legal challenges or are they going to be joined? Let's clarify that.
Well, you know, if we were arguing the same case, or rather had same concerns with the Democratic Alliance, we would have approached the court and wanted to join that case. But because we are arguing different things, we're not opposed to transformation. They're challenging the very fact that gives effect to this target. That's not what we are arguing. We're simply saying that the act is there. Now follow the act in implementing it and setting the targets. That's one part. The second part is of course, that we think that an appropriate platform for hearing a matter such as this one is the Labour Court, because these are labour matters, and so this is where we have filed our application, because we think there's better appreciation of these issues in the Labour Court. Again, it separates us from those who are arguing different points of law in regards to this very act. We are basically saying, follow the act so that you arrive at an outcome that is acceptable to everybody.
Mr. Mathe, thank you so much for that clarification and also for talking to us this evening. And that was Khulekani Mathe, CEO of Business Unity South Africa. We are going to be trying to reach out to the department as well to get their own reaction, particularly to this particular matter, because it is quite the big one. So certainly we'll circle back to that conversation with the Department of Labour.